Hi, I'm Catherine Gannon and I'm the founder and managing partner of Gannons. Gannons is a specialist practice set up over 20 years ago to help private companies thrive and survive. I was in the city and I could see that no one really cared about the private sector, and yet it was a much more important producer of gross national product than the FTSE 100 companies. So I saw a gap in the market and thought I'm going to plug that. Most companies need a shareholders agreement if they've got more than two shareholders. Most people wish they had a shareholders agreement when they're in difficulty, and because we work for so many private companies where unfortunately opinions on how to run the business can vary, we've got the experience and practice of putting in place many types of shareholders agreements. The main reason for these shareholders agreements is the bylaws, which are downloaded when you first set up a company, miss some very, very important factors such as getting shares back when people leave, powers of veto. So without a shareholders agreement, your business is very exposed. The problem is litigation is so expensive, most people never take them to task. So they do have a free rein. However, the block comes in the form of shareholders, because there's various steps shareholders can take which can block and U-turn decisions of directors. What the shareholders agreement does is make it very clear that the shareholders will have the trump card. With a minority, you're not going to win on any vote because you don't have more than 51%, or to change the articles and take really big decisions, 75%. But often the minority shareholders have invested quite heavily and they do need protection. There are a number of protections. It very much depends on the facts and the risk areas. One of the biggest protections is to have what we call powers of veto, which is to list various steps directors cannot take without shareholder approval. And that shareholder approval can be anything from 51% to 100%. So for example, you might want to put a curb on spending. You might want to put a curb on them going out buying other businesses. You might want to put a curb on development costs. All sorts of things you can put restrictions on via a shareholders agreement. There's two sorts of articles of association. There's articles of associations downloaded when you set the company up, and they don't really cover anything when you need them. Then there's bespoke, tailored articles of association that will cover anything you've discussed that needs to be covered. The beauty about articles of association is they're an open document, everybody knows what their position is, but that can also sometimes be a hindrance, which is where shareholders agreements come in, because they're private documents. The world at large will not know what is in your shareholders agreement, whereas the world at large will know what are in your articles, because they're filed at Companies House. Many companies don't need shareholders agreements if they've got decent articles of association. Fortunately, people fall out, and if you've only got the model articles that were provided when you set up the company, anyone leaving the company, leaving employment, leaving directorship also walks away with your shares, and there is no way to get them back. So it is highly recommended that you have good and bad leaver provisions in either your shareholders agreement or your articles. You don't need them in both documents, but you do need them in one document. And what you say about leaving can vary. So you can carve out circumstances. You could say if someone dies or if someone gets run over, they can get the market value for their shares. Conversely, you can say if somebody's gone off to join a competitor, they're going to get nothing back for their shares. It's a conversation we need to have. You want to motivate the employees, and you want to motivate the employees to stay, and that's all tied in with how you deal with your good and bad leaver provisions. Depends how the business goes, the flavours, the personalities, investment rounds, that type of thing. There's no straight answer. Articles you can amend usually, unless you've overridden that right, with 75% of shareholders voting for the amendment. Shareholders agreements, everyone has to approve the amendment. So that again is something to consider when you're putting in place the structure for how you're going to regulate your business. The essential, again, clauses that could go in either articles or shareholders agreements. And what they mean is if the majority of the shareholders want to sell the business, the minority shareholders are dragged in, usually on the same terms, i.e. the same price as the majority shareholders. Companies are unsaleable without those clauses because no buyer wants to come along and do all the due diligence only to find one irksome, irritating little shareholder refuses to sign up. So really important to get your drag and tag provisions in place. Again, the sooner they can be put in place, the better, because if you have reached a stage where you want to sell and you suddenly start asking people to change the articles, they get suspicious, they can start negotiating, things can be much more difficult. If you can afford to do all this at the very start, life will undoubtedly be easier for you.